No pressure. We're expecting. Thanks. Please be seated.
Good forward.
Haven't had anybody come up on the board yet. There's.
Oh.
Okay.
Morning. Same thing by my very capable young trial counsel said earlier. Good afternoon. Ms. Price, if anything, if at any point when I'm seeking to place my opinion on the record, if I'm not enunciating clearly or if you don't understand what I'm saying, please interrupt me, okay?
Okay,
All
thank
right.
you.
Thank you. Thanks for being with us. All right. Good afternoon. Today is May 12th, 2025. Time is 3:30. This is the time and date that, and this is the matter of Krieger et al. Versus the Michigan Department of Environment and Great Lakes and Energy et al. Court of Claims case number 2020-00094 et al. There are many other captioned plaintiffs in the case, many other case numbers. We've been together many times in this case. This is the time and date that I've set for placing my opinion on the record on the motions for summary disposition filed by the defendants. Are there any other attorneys? I saw two lawyers were going to be appearing. I don't know if they're
We have 28 people currently, they're monitoring this.
okay.
So I assume there's at least.
All right. So, Mr. Gamble, the attorney for the state of Michigan defendants, is present here in the courtroom. Ms. Almanrode and one other attorney. And let me get my notes. Do you know who the other attorney was who said he was gonna?
Possibly Mr. Paulson.
Yeah, I think it might have been. Right. Mr. Carlson is indicating his attendance today and Ms. Almanrode. And if there are other lawyers who filed an appearance and I didn't say your name, it's not because I don't hold you in the highest regard. It's because I have many stacks of paper in front of me. And if I try to find everything, we'll be here until 4:30 just looking for lawyers' names. And that would not be an efficient use of everyone's time. All right, before I proceed to my opinion, which I will memorialize with an order, I want to thank the attorneys for the defense and the plaintiffs. They have submitted very comprehensive and thoughtful and well-prepared briefs in support of their motions or in defense of the motion. The record is in excess of 2,400 pages just on these three pleadings. A lot of thought went into it, a lot of hard work on behalf of the plaintiffs who, whether you're a member of the class who's named or putative class, I should say, that we haven't endorsed class yet, or you're the director of a state agency, you should be assured that the counsel is representing you and the claims that you're putting forth or the defenses that you're asserting have all done a very capable job in this briefing, as well as throughout the litigation of this case. So thank you, Mr. Gamble. You're here in person, so you get personal thanks, and thanks to the other lawyers who are attending by Zoom. I'm very grateful. My name is James Robert Redford. I have the privilege of serving the plaintiffs and the defendants in this case. This is a matter that has been on the Court of Claims docket for some time. So thank you. I appreciate everyone's work. I'm going to largely be looking at my notes. So if I don't look up, it's not because I'm trying to be discourteous or not have eye contact. I'm doing what we used to always tell the young lawyers in trial advocacy: don't work off your notes. Go by, but there's just too much information in this matter. All right. So what I always used to tell my law clerks when I was a circuit judge in Kent, when I had the privilege of serving there, or when I was a lawyer in private practice, when I became a partner and then had associates working with me, is always give the punchline up front so everybody knows. So it's not this. You're not writing a novel. You're writing an opinion to assist the litigants. So I will take my own advice and counsel, and I will indicate what my ruling is going to be up front, and then I'm going to explain the reasons for it. I will tell you right now, I have 14 pages of typed notes, plus about 3 other pages. It's going to be memorialized in a very short order. But the bottom line is that for the reasons which I will state orally here on the record, the defendant's motion for summary disposition under MCR 2.116 C10 is denied without prejudice today. The reasons for this, I think it's reasonable to give somewhat of a background for purposes of any reviewing tribunal's responsibility of needing to review the case. The matters giving rise to this litigation in this action are the result of the failure of an earthen dam in mid-Michigan called the Edenville Dam. The dam failed May 20th, 2020. Next Tuesday, it will be 5 years to the day from when the dam failed. 2 days after the dam failed, on May 22nd, 2020, the Krieger plaintiffs filed the first complaint in this matter. Many subsequent and additional complaints have been filed thereafter. On August 30th, 2020, in lieu of an answer, the defendants, as is authorized under Michigan law, filed a motion for summary disposition under MCR 2.116 C7. On October 5th, 2021, the trial court granted in part and denied in part the defense motion. Subsequent to that decision, appeals were taken to the Michigan Court of Appeals, which affirmed the Court of Claims decision. At that time, the Honorable Cynthia Stevens, one of my predecessors in interest on this case, and her decision continued, and that appeal process continued. Excuse me, part of my materials just fell on the floor, so I'm going to pick those up. How appropriate. The appellate process from the October 5th, 2021 decision continued until November 15th, 2023, when the Supreme Court of this state denied leave to review the Court of Appeals decision. On January 30th, 2024, the matter was assigned to this court, to me. On February 2nd, 2024, I issued an order for a status conference. The parties, through their counsel and the court staff, just as the previously assigned judges of of this court and those judges, previous staff members, have all been working diligently to advance this entire series of cases. On January 31st, 2025, defendants represented by Mr. Gamble, the Michigan Department of Environment, Great Lakes and Energy et al. Filed a revised brief in support of its September 5th, 2024 motion for summary disposition under MCR 2.116C10. Plaintiffs filed a response brief on March 7th, 2025, and then a corrected response on April 19th, 2024. Defendants replied to plaintiff's March 7th response on March 21st, 2025. The parties' briefs with exhibits, captions, signature pages, and the remaining documents attached to them combined to be 2,651 pages. As I told these very capable lawyers a week ago, I did not read every page of the exhibits. I absolutely can assure the parties I read every single page and most pages multiple times of the briefs, reply and responses and replies. I read a lot of the exhibits, but I did not read 2,651 pages in their entirety. All of the filings were filed before the end date of discovery in this case, which was May 1st, 2025. Last Monday, May 5th, 2025, the parties appeared for oral argument on the motion, and at that time, the court was advised that at least one expert's deposition had yet been completed, and there were certain models used by experts in the case that the parties were still working on and discussing, and a review of the transcript from the May 5th, 2025 hearing will reveal the discussions that the court had on the record. The bottom line is there's some limited, albeit, but there is some expert discovery that's continuing and other discovery. I think just expert discovery that's continuing. Not much, but some. Pursuant to the court's order dated February 10th, 2025, summary disposition motions after the close of discovery are to be filed no later than July 3rd, 2025. Currently, oral argument is scheduled if the case continues. Well, it will, because I already told you I'm going to deny the motion. So the oral argument on those motions will be September 15th, 2025. Off of my notes, off of my script, I will tell counsel this has been so well argued, so well briefed. It's possible I'm going to let the parties know additional oral argument is not necessary, but I'm not sure. I have not made that decision. And if you do want, if a party files a subsequent motion or summary disposition and you do seek oral argument, please just indicate on the cover oral argument requested so I know. I do think everybody has argued this thing so well. I'm not sure we need it, but it's an important case for the court. And it's far more important for the parties. I understand that. So I'm not saying that definitively. So what is before the court today? Today, we have a motion for summary disposition filed pursuant to MCR 2.116C10. This court will authorize a summary disposition when, quote, except to the amount of damages, there is no genuine issue of any material fact and the moving party is entitled to judgment or partial judgment as a matter of law, close quote. Generally, the granting of, and this is quote again, generally the granting of a motion for summary disposition before discovery on a disputed issue is complete is considered premature. See Bain, B-A-Y-N versus Michigan Department of Natural Resources, 202 MISHAP 66 at page 70, 1993. In order to find in a defendant's favor in a circumstance such as this, the court must find that there is no fair chance that further discovery will result in factual support for the party opposing the motion. Mackey versus Department of Corrections, 205 MISHAP 330 at 333, 1994. To defeat such a finding, the plaintiffs must identify a disputed issue and support that issue with independent evidence. See Meisner, M-E-I-S-N-E-R, Law Group, PC versus Weston, W-E-S-T-O-N, Downs, Condominium Association 321 Mishap 702 at 7/23/2017, quoting Maryland Froling Revocable Living Trust versus Bloomfield Hills Country Club 283 Mishap 264 at 292/2009. Excuse me. I have my cell phone in court so I can access our computer system if I need to. But there was a call that I just turned it off. That's what I was doing. I apologize for that interruption. If I were in the 61st District Court when I was still practicing, I was in front of one of my previous friends, they would have been saying, Mr. Redford, the phone now belongs to the court. But yeah, I'll turn it in afterwards. All right, continuing. The granting of summary disposition in White v. Taylor Distributing, the Court of Appeals wrote, quote, granting of summary disposition is suspect and improper where the credibility of a witness or a deponent is crucial. 275 Mishap 616 at page 626, 2007. And of course, that which all of us who have litigated civil cases in Michigan know, Skinner versus Square D, 445 Michigan 153, 1994, at page 161. In Skinner, the Supreme Court, and cited by literally generations of lawyers, my P number's 38. I think Mr. Gamble's is 75 or 80 something. I bet both of us were taught this when we were first trial practitioners, as I'm sure Ms. Almenrode and the other attorneys of record. So Skinner v. Square D, quote, the court is not permitted to assess credibility or to determine facts on a motion for summary disposition. That's under C10. Instead, the court's task is to review the record evidence and all reasonable inferences therefrom and decide whether a genuine issue of material fact exists to warrant a trial, period, close quote. In the matter before the court, the sole remaining claim being made or sought to be made by either class plaintiffs or individually named plaintiffs is inverse condemnation. The elements of this cause of action were analyzed by the Court of Appeals in this very case. At 348 Mishap 156 at page 182, 2023, Krieger versus Eagle. The Michigan Court of Appeals set forth a standard for evaluating claims for inverse condemnation. The Court of Appeals specifically recognized the availability of inverse condemnation in situations where the government action caused flooding, and it quoted the Wiggins case, where the court said, quote, Michigan recognizes the theory of inverse condemnation as a means of enforcing the constitutional ban on uncompensated takings of property, close quote. It is a cause of action against a governmental defendant to recover the value of property which has been taken, even though no formal exercise of the power of eminent domain has been attempted by the taking agency. It can occur, quote, without a physical taking of the property, a diminution in the value of the property, or a partial destruction can constitute a taking. That's Wiggins versus City of Burton, 291 Mishap 532. Generally, the elements are one, that the government's actions were a substantial cause of the decline of the property's value, and two, the government abused its power in affirmative actions directly aimed at the property. See the Krieger case, 348 at pages 182 through 183. As has been correctly briefed and argued by the defense, authorizing a permit in and of itself is not sufficient. The court fully I fully understand and recognize that. And that's in the Attorney General versus Ankerson 148 Mishap 524 at page 562. In 1986, it was decided, and the Krieger court said, quote, nearly 40 years ago, we held that the state's alleged misfeasance in licensing and supervising a waste disposal operation did not constitute affirmative actions directly aimed at the counter plaintiff's property, period, close quote. Krieger 348 at 182 and 183. Likewise, alleged inaction and omissions by the state could not sustain such a claim. Krieger 348 at 184. Active steps and actions have to be taken by a governmental agent to support the claim of a taking. If all that was present in this case was a permit having been issued or not declined to be issued, the plaintiffs would not have met their burden to sustain being able to continue to litigate the case beyond the C10 stage, because a permit is not enough. There is more in the record, however, than simply the denial of the permit. And at this stage of the proceedings, this court is required to take all evidence in the light most favorable, as well as the inferences from that evidence, in favor of the non-moving party. The opinion to deny C10 relief is not an opinion which states the plaintiffs will win this case at trial. That's not the standard. This case, if allowed to, will go to trial. And the trial court will have to weigh and evaluate the credibility of the evidence in a standard and in a manner which is far different from that in the C10 motion. As was argued by the government, they being the plaintiffs can't, and I'm not, this is not a direct quote, I'm paraphrasing counsel for the defense. They can't sustain their burden by simply because we just didn't issue the permit. But that's not all that they've alleged, nor is that all the evidence that they have. The defendants, the plaintiffs allege that there is more than simply the issuing of a permit. The parties' briefings submitted in connection with this or in response to Eagles and DNR's motion for summary disposition, in my assessment, having carefully reviewed it, clearly create factual questions as to whether or not Eagle knew that the Edenville Dam presented a safety risk through the FERC order, which is the Federal Energy Regulatory Commission order, revoking the license, as well as the Spicer Group report. And if they knew this, did their actions result in the denial of Boyce's request for a winter drawdown in 2019 and the subsequent either actual commencement of litigation or communication that litigation would be commenced because of the drawdown impact the level that the water was retained at? The defense has argued, and I understand the argument, Judge, it doesn't matter what the level was, because what caused the failure of the Edenville Dam was the liquefaction of the soil, not the water level. I understand that argument. That argument can be made at trial. But when we are required to take the evidence in the light most favorable to the non-moving party, we look to what the factual record is before the court. Some examples of factual questions, and if I give page numbers, these are to the plaintiff's corrected, revised brief. For example, in the record, there are allegations that Eagle had notice of the dam's potential for failure with significant damage, as is evidence at page 107 of 1,385 pages. The Federal Energy Regulatory Commission's order revoking the license recognizes Boyce's quote, and Boyce being the operator, I think, and owner of the dam at the time of the dam failure, Boyce's quote, longstanding failure to increase the project's spillway capacity to safely pass flood flows, period, close quote. Also, on September 13th, 2018, there's an email from Lee Mueller to Luke Trumbull expressing the quote, sense of urgency that should be applied to the scheduling of the MDEQ Dam Safety Division inspection of the Edenville Dam, close quote. Likewise, at page 604 of the record, 1385, 1,385 pages, is the Spicer Group report, which was prepared for the Four Lakes Task Force, which states currently there are deficiencies which need to be corrected. I indicate for purposes of subsequent appellate review, if it becomes necessary by a different tribunal above this trial court, that the FLTF, Four Lakes Task Force, is a combination of counties and that got together to try to manage, if you will, and potentially take ownership of the Edenville dams. Yeah, the Edenville dam after the federal regulators withdrew their licensing to allow the Edenville Dam to continue to produce hydroelectric power. In the Spicer Group report, it states, quote, currently there are deficiencies which need to be corrected. The dam does not provide adequate capacity to pass 1/2 the probable maximum flood PMF event sufficiently to meet Eagle Dam safety requirements. This has been previously identified during the review of the rating curves by the Eagle Dam safety engineers and confirmed by the FLTF Four Lakes Task Force engineering team, period. Page 604 of 1385. It continues, quote, the Edenville Dam is classified as having a high hazard potential due to the impact that a potential failure could have on downstream developments, potentially for loss of life and potential for failure of downstream dams, period, close quote, 606 of 1385. At 610 of 1385, it's stated, quote, as reported by Eagle, the Edenville spillway capacity is 11,102 cubic feet per second, and the Tobacco Dam has a spillway capacity of 9,967 cubic feet per second. The rating curve from Eagle is included in Appendix B. The 1/2 PMF, which again is the probable maximum flood, is 25,900, and therefore existing spillways do not have the capacity to pass this flow. Dam modifications are being considered to pass this flow through a passive auxiliary spillway, and supporting modeling is being developed. Page 610 of 1,385. Just a moment. It is anticipated at page 610, it also states it is anticipated that an additional auxiliary spillway will be needed, and the FLTF engineering team is currently working on a PMF study and planning for additional spillway capacity and phase 2 improvements on both sides of the dam, page 610 of 1385. One witness proffered for the plaintiffs, Mr. Sturdivant, testified as a deposition that, quote, he considered the normal pool, which is the lake level of Wixom Lake. That's not in the quote, but I'm explaining what the normal pool is. So Sturdivant testified, quote, considered the normal pool to be dangerously high given that the dam was not capable of passing the flows that it was supposed to by regulation. That's page 189 of 1385. He felt that the winter level was less dangerous given the inability of the reservoir to attenuate flows with just that 3 feet. That would not be enough. He also opined that, quote, failure of the spillway at the Edenville Dam to satisfy the state of Michigan's PMF rules had a role in causing the dam's failure because it couldn't pass the water to keep the water level low enough in the reservoir and allowed the water to rise to an elevation that caused total saturation and liquefaction of the embankment. This also increased phreatic, spelled PHREATIC, surface within the earthen embankment on May 20th, 2020. This is at page 404 of 1,385 of the plaintiff's submissions in response to the defense's motion. He continued, water level, quote, increases to the point where you can and did result in embankment instability, page 406 of 1385. I recognize that at pages 15 and 16 of the reply brief filed by the defendants on March 21st, 2025, there is exception taken to the testimony of Mr. Sturdivant. In their brief, I always want to say the people when it's the AG. The defendants, the state agencies state through their very capable counsel, quote, plaintiffs fail to rehabilitate the reliability of their primary expert, Mr. Sturdivant, upon whose statements plaintiffs rely extensively. As defendant showed, Mr. Sturdivant has no experience with Michigan statutes he is tasked with interpreting for the court, is not familiar with the regulatory rules of Eagle and DNR, and cannot identify the roles played by the writers or recipients of emails he reviewed, period, close quote. And it continues for a couple pages talking about the various reasons the evidence is insufficient to satisfy that which the plaintiff must do in the face of the motion. At this stage of the proceedings, however, there is sworn testimony on the record, a witness proffered to be an expert, and the court is obligated to take it in the light most favorable to the non-moving party. And I don't, all the lawyers have heard me say it before. I mean, I've had the privilege of being a circuit judge for 12 years and just the most wonderful place I've called home since 1990 when I left active duty in the Navy. Had probably 4,000 civil cases, had 234 jury trials, hundreds and hundreds and hundreds of motions for summary disposition. And you just, at this stage of the proceedings, it's the arguments, and we see it in applications for leave to appeal here in the Court of Appeals, where I also serve. If there's a factual question on the record that's before the trial court that has to decide a C-10 motion in our court, it is my understanding when we take the evidence in light most favorable to the non-moving party on a material issue, and it are these two elements met by the plaintiffs. I just think that the Sturdivant testimony standing alone, it would be enough that I would be required to deny the motion. And who knows, maybe in the short run, somebody will tell me I'm wrong, and then that's fine, or maybe there won't be an interlocutory review. I just don't know. I hope we're able to move forward, but I understand everybody has rights, and I am by no means the last word on this case. But that's when I look at that case, and I'm obviously judging this case based on the law of the state of Michigan, on the record before me. I'm not basing it on, I did 4,000 civil cases, so I got to do it this way. No, but I'm just saying, I've had the privilege of serving in a lot of other cases, and I get what the role of the trial court is here. I think I do anyway. And I think that there's enough questions based on what I've just already said, and I'm going to say some more, but I go off of my prepared notes. I don't mean any disrespect to any of the lawyers on either side, for the defense or the plaintiffs. I think that's what the law requires at this point of the litigation. And I'm not at all, yeah. So that's where I'm at. In addition to this, there is testimony at there's evidence at page 504 of 1,385 of a witness, Pawlowski, Pawlowski, a retired Eagle Dam Safety Inspector, testifies at a deposition. The purpose of a drawdown is to, quote, reduce the risk of threat of the dam failing, close quote, and a drawdown is a, quote, mechanism to address, quote, a spillway capacity deficiency at page 504 as well. He testified that it was correct that the drawdown provides an advantage, quote, in that when a flooding event would happen, the starting point of the water level would already be lower or relatively lower than before drawdown, period, close quote. Walski said also at page 504 that a drawdown gives you a little bit of a buffer, and you can end up of storing some of the water in the impoundment as the water in the impoundment rises, and you may be able to pass the design flood. Also in support of their response was an expert report of W. Allen Marr at page 750, professional engineer, PhD, who discussed the water levels. Some of the affirmative actions that Eagle is alleged to have done, which the plaintiffs argue is satisfies some of the elements, the two elements, is that on November 25th, 2019, Eagle sent a letter to Mr. Mueller denying the Four Lakes Task Force application for a winter drawdown of 8 feet, 511 of the record of 1,157 pages. I recall some of the arguments of very capable defense counsel said it doesn't matter. That doesn't matter because they still drew it down anyway. But it can matter because if the state has said you can't do this through a declaration, a letter, an order, whatever it is, and we take the reasonable inferences from that, that can impact, there's a reasonable inference that that would impact the decision or decisions as things move forward. Additionally, there's an enforcement notice that is sent December 12th, 2019, letter to Mr. Mueller regarding the drawdown below the elevation of 672.8 NGVD, which is a specific amount of water in the reservoir allowed under the circuit court order. In it, Mueller and the Four Lakes Task Force with Spicer Group serving as a consultant applied for permits to restore the normal lake levels. The permit authorized this. And then the Four Lakes Task Force dated April 8th states that time is of the essence to raise Wixom Lake level to its normal summer level. Period, close quote. That's at 547. Subsequently, also of record, Eagle sues Mueller and Boyce, Michigan, due to significant drawdowns, which took place in 2018, refilling it in the spring of 2019, and then the drawdown in the spring, and then drew down in the spring of 2019, which was, quote, expressly destructive to the freshwater mussel, MUSSEL, community on Wixom Lake, page 569. The state sought an order under MCL 324.30316, quote, requiring Boyce to restore the affected wetlands as nearly as possible to their state prior to the drawdowns, along with an assessment of civil fines, period. The Sturtevant Declaration says the state not only authorized but forced the water levels of Wixom Lake to be raised when they had knowledge that the dam was dangerous and unsafe, and that it had been deemed unsafe by the Federal Energy Regulatory Commission. He also states that the dam qualified as a high hazard potential dam when it did not satisfy the state's PMF, the probable maximum flood. Sturtevant observes that the rejection of Boyce's request for a drawdown to lower the lake level and then threaten legal action when Boyce lowered the lake levels anyway also goes into his opinion forming. He said the state actively participated in the petition to set water levels with reckless disregard to the dangers caused by the unsafe condition of this high hazard dam and deliberately disregarded the necessity to undertake immediate efforts to mitigate the danger it posed. And on April 2020, it issued a permit to Boyce to raise the lake water levels and condition the permit on Boyce maintaining high water levels without further drawdowns. This is in a deposition January 14th, 2025, which begins at page 722 of 1,157 pages. Mr. Sturtevant also provides declarations on December 5th, 2024, which suggests that he believes that Eagle actively moved to prevent Boyce from drawing down the lake level, pressured Boyce to raise the lake level, and concealed the risks the dam condition posed, and that the defendant exercised operational control over the dam. He said that high water levels resulting from raising the lake level further reduce the dam spillway capacity and increase the phoretic water surface on the dam. He has several other opinions about priorities of the state and other scientific conclusions that I believe, when taken in the light most favorable to the non-moving party, prescribe C10 relief. I would note that the court is familiar that there are two previous federal trial court decisions that have been made giving under the allegations about the failure of the Edenville Dam. And one federal appellate court has granted relief in favor of the defendants. The two trial courts granted relief in favor of the trial of the defendants. I am familiar with 4 of the 5 judges who either were the trial court judges or members of the appellate panel. I have absolutely nothing but the highest regard for the jurists who I know who are on that. It doesn't matter. And I'm not ruling one way or the other because of how somebody else ruled. But my point is, I know that judges have ruled on this and granted the relief that the defense seeks in this case. I've read all 3 of those opinions. The motion before this court today, though, must be based on a record that is before this court, not the record which may or may not have been before another court. I am satisfied on my review of the record with the benefit of many meetings in person, telephonically, motion hearings, reviewing of thousands of pages of transcripts, documents, and briefs. Since I've had the privilege of being assigned this case on my docket at the end of January 2024, that the facts of record at this time, taken in the light most favorable to the plaintiffs, prescribe the court's ability to grant the relief that the defense seeks. It is for these reasons that I respectfully deny the motion for summary disposition. I'm signing an order here in open court. The time is 10 minutes after 4 on May 12th, 2025. The order will state, it's captioned, order denying defendant's motion for summary disposition under MCR 2.116C10. And it states as follows: for the reasons stated on the record, defendant's September 5th, 2024 motion for summary disposition under MCR 2.116C10 as revised on January 31st, 2025 is denied without prejudice. This is not a final order resolving all issues in this case. It is so ordered, dated May 12th, 2025. Time is, of course, the pen doesn't work. Signing the record in open court. I did ask my assistant if I could get extra copies so I could, when I was advised, well, when I had a nice chance to visit with Mr. Gamble previously that I was here, and I was advised, Mr. Gamble, Judge, we will send it to him immediately. He's going to get it when everybody else is, right after it gets filed. So I don't have a copy for you, Mr. Gamble. I do appreciate your taking time out of your busy schedule to be with the court today. I didn't know he was coming. It's always nice to have people in the courtroom. We have two very fine, a fine young lawyer and a fine young law clerk for one of the other judges is here. Is there anything you'd like to say?
Yes, Your Honor, if I may, as the court knows, the court rules require that prior to seeking a stay from the Court of Appeals, we have to go to the trial court first. And so I'd just like to move for a stay of the case pending appeal. Thank you.
Your motion for stay is respectfully denied. And I will, and none of the other lawyers are present, but the motion for stay is respectfully denied. I'll draft a quick, like, 1-sentence order that says, following the pronouncement of the opinion and order and the issuing of the order, the defense counsel being present in court made an oral motion for a stay. The motion is respectfully denied. And then we'll get that set so you can ask the Court of Appeals to do whatever the Court of Appeals would like to do. Okay, and then Ms. Price, if if any of the lawyers order a transcript, which I'm assuming somebody's going to have to if you're going to appeal it, if that does happen, if you could advise our clerk's office, and I'll be asking for a copy of the transcript as well.
Okay, thank you.
All right, Ms. Price, anything else we need to address before we finish for the day?
I'm sorry to bother you. If I may, real quick, who was the counsel that just spoke for the motion for stay?
Thank you. Mr. Gamble, do you want to make your appearance?
Yes,
Thank you.
Nick Gamble on behalf of the defendants.
Okay, thank you, Ms. Price, for catching as usual. I made a mistake. So, okay, all right. Dan, anything else? All right, thank you. The court's in recess. Thanks. Thank you, Ms. Price. Okay, good.